We'll get started in just a minute. Good morning or good afternoon, wherever you might be watching this webinar. I'm Rick Hassan of UCLA School of Law and director of the Safeguarding Democracy Project. We hold a fall and spring webinar series. We're off for the summer, but we've decided to put together this special flash webinar on the topic of the Supreme Court's decision this week in Moore versus Harper. A decision that involves something that's been called the independent state legislature theory. It's very important for those who care about the relationship between state courts and state legislatures and the US Supreme Court and American democracy. It's a complex topic, but a really important one. And I'm thrilled that we've got an all-star panel to discuss these issues. I'm going to really briefly introduce them, and then I'm going to have Ben Austin DeCampo, the program coordinator of the Safeguarding Democracy Project, put the links to their full bios into the chat so you can look at those. Professor Derek Muller holds the Ben V. Willey Professor in Excellence at the University of Iowa College of Law, and he will soon be a professor of law at Notre Dame Law School. Professor Carolyn Shapiro is Associate Dean for Academic Administration and Strategic Initiatives at Chicago-Kent College of Law and the founder and co-director of Chicago-Kent's Institute on the Supreme Court of the United States. Bertrall Ross is the Thurgood Marshall Distinguished Professor of Law at the University of Virginia Law School. And Richard H. Pildes is the Sudler Family Professor of Constitutional Law at NYU School of Law. I'm really thrilled to have this panel here today to discuss this case and unpacking it. I didn't even know if we were going to get a decision in this case because there was a question about whether or not the case was moot, whether it could even be heard. And before we get into the merits, let me turn first to you, Derek, and just ask you to explain, why was the case possibly moot? Why was it that we weren't sure up to even the minutes before the opinion came out if we were going to get an opinion in the case? And how do you think the court resolved that question? There was a dissent from 3 justices on the mootness question.
Yeah, it's been a winding path for this case over many months. You know, this case came up before the Supreme Court in an emergency posture in February, March of 2022. So it's been languishing for a long time. And in the interim, the North Carolina Supreme Court turned over personnel. It had an election in the fall of 2022. And then there was an attempt to have a rehearing on the original case dealing with the gerrymander. And so there's a series of cases with Roman numerals all involving Harper about sort of getting the order in this case. But while this case was pending in front of the Supreme Court after argument, the North Carolina Supreme Court granted rehearing on a related case, had oral argument, and issued a decision essentially saying not only that the North Carolina legislature could institute the maps that it wanted, but that its previous decision finding that the North Carolina Constitution prohibited partisan gerrymandering was overruled. And so this set up a question about, well, if the one thing at the core of this case about what the state Supreme Court did is gone, is this case moot? And there was a lot of supplemental briefing. The Solicitor General, for instance, said the case was moot, and there was a lot of posturing here. The majority came out and said, look, at its core, this case is about this 2021 map that the legislature implemented with a judgment there. And whatever the North Carolina Supreme Court did in 2023 didn't alter that judgment. That judgment is still there, prohibiting the 2021 map from going into effect. And if that's the case, we still have jurisdiction to address that issue and whether or not the North Carolina legislature can do it. And the dissent looks at it and says, it looks like they've gotten everything they wanted. There's nothing else that we can really give as a matter of practical relief, but at least formally for the majority, they said, we can step in, we can give a judgment in this case and issue a decision that will affect the parties, and they did so.
And what about Justice Thomas's dissenting view on this?
I mean, he was very much looking at this as a very practical matter. And again, I think more consistent with the Solicitor General's view to say, look, I mean, there's really nothing left here for us to decide. If we send this back, the North Carolina legislature isn't going to use the 2021 maps. It's going to do something else. Or even if it wanted to, it could draw a new map and use the 2021 map as a template and do exactly the same thing it wanted. That really, there's nothing formally that's changed if we issue a judgment that somehow does something to what happened with that 2021 order, wherever it was pending at some previous place in time. The precedent that says North Carolina has an anti-gerrymandering provision in its state constitution is gone. And if that's gone, what are we doing deciding this case today?
Rick, can I say a couple things about mootness?
Yes, please.
So first, one of the things that's kind of fun about the case, if you will, is there's sort of an irony about this whole mootness issue, because the North Carolina legislators who were looking to overturn the Supreme Court decision, who were represented by the Cooper Kirk law firm in DC, they argued the case was not moot. And the Supreme Court basically accepted their theory as to why it wasn't moot. And then they lost the case on the merits. Conversely, several of the parties who won the case had been begging the court to find the case moot and not to decide it. So I think that's kind of an interesting twist here. The other thing I want to put into the mix is I commend the court for finding the case not moot, because as many of us in the election law field have said, it was incredibly important that we get some clarity about this doctrine or doctrines. And if there were any basis for the court continuing to find it had jurisdiction, many of us thought they should seize on that basis, which is exactly what they did. It's just ironic that the roadmap for that was given to them by the party that then lost on the merits.
And can I also add something?
Please.
I think that there's another irony here, which is that in 2021, when the Supreme Court did not grant cert in a case that had arisen during the 2020 election out of Pennsylvania, Justice Thomas wrote an opinion, a dissent from the denial of cert, arguing that the court should have granted cert in that case because this was such an important issue and it needed to be decided. And in election law, there's a little more flexibility around mootness. So there's no question that in that case, there was nothing left. The election was over. Joe Biden was president. So I do find that a little ironic as well.
Yeah, we could talk about Justice Thomas and irony in that he also rejected the theory of the independent state legislature theory that that he had signed on to in Bush versus Gore. But we'll get to that in a moment. Let me stick with you, Carolyn, and just ask you, if you looked at some of the headlines, it was Supreme Court rejects independent state legislature theory, and that seems to be wrong, and we'll get to what the court accepted. But the court, I think it's clear, did reject the most extreme or maximalist version of the independent state legislature theory. So what was that theory? Why did the court reject it? And where were Justices Thomas and Gorsuch in dissent on that question? So now we've turned from the technical mootness question that Derek just addressed to the merits.
So the extreme version, which definitely has been rejected, is that because the elections clause says that time, place, and manner of congressional elections is to be determined by the state legislature, and subtext probably also because the electors clause says that state legislatures determine the method by which presidential electors are appointed, that the state legislature has some kind of unique ability to act without the normal checks and balances provided by the state constitution and by the judiciary. At its most extreme version, this would mean that, for example, state constitutional provisions that provide for anti-gerrymandering requirements, which have now been enacted in a fair number of states by citizen initiative, would be inapplicable to congressional redistricting. They simply could not apply. It means that state constitutional provisions that date all the way back to the founding that say things like voting for all offices shall be by ballot would not necessarily apply to federal elections. it would really unmoor state legislatures from the what creates them, which is the state constitution. And at its most extreme, it would provide absolutely no limits on what they could do with respect to state under state constitutional law, and would not allow for any kind of judicial oversight by the state courts.
Okay,
Now,
and you did use the term unmoor, and I just can't resist that. I was going to call this democracy unmoored. That wasn't quite right, but I did notice that. But where did Thomas and Gorsuch, again, Alito, who's also in dissent, only dissented on the technical point about mootness, did Thomas and Gorsuch embrace the theory that the North Carolina legislators put forward, or was there some nuance there in what they were saying?
well, I mean, I think that they say it says legislature, and that means legislature. And so there's not a lot of nuance there. Justice Thomas then goes on to criticize the majority for this guy, I think, gets into your next question, but criticizes the majority for suggesting that there will be some kind of federal judicial review of state courts' interpretations and applications of their own constitutions. And that opens a whole Pandora's box of problems, which may well be true, but I don't see how that's really significantly different from the even bigger Pandora's box of problems that his version would result in.
I don't know if any of you else want to weigh in on this. Before I'm going to turn to Bertrall in a minute and ask kind of what the political implications of all of this are. But maybe before we get to that, let me turn to Rick Pildes and ask the question, right? So you said, I think in your introductory remark, independent state legislature theory or theories, right? So there's kind of this nomenclature thing. Is ISLT dead? Right? So one version is dead, but there's something else that's still there. And so what is it that the majority said is the proper role of state courts in relation to state legislatures when it comes to federal elections? And you had a piece in today's New York Times that says that this creates some uncertainties and some dangers.
Yes. So one of the things that's been difficult in talking about the case publicly is there are a number of versions of a potential independent state legislature doctrine or theory. They're not all the same. The implications are not all the same. The court resoundingly rejected, as Carolyn was describing, the most extreme version of the theory, the version that would really have dramatically destabilized federal elections. But at the same time, they actually did endorse a weaker version of the theory. And I think we no longer call it a theory. It's a doctrine now. You know, the court established that there are federal constitutional constraints that apply not just to state courts interpreting their state constitutions when it comes to federal state statutes regulating federal elections, but I think this doctrine clearly applies to all state actors, state election administrators, implementing state election statutes for federal elections, as well as state courts. And what the court held here is that there is some boundary that other actors can't transgress when they're working with state election statutes. But they didn't give us any real sense of what the content of that boundary is. So they said things like state courts don't have free reign. They said state courts cannot transgress the boundaries of something like ordinary, judicial review and the like. So, and Justice Kavanaugh wrote separately, and I think a main reason he wrote separately, I think partly he wanted to explain why he was coming out this way after some of the statements he had written in the 2020 election context, but also I think he wanted to lay down a marker that he thinks this doctrine really has some teeth. And so he wanted it to be clearly understood that the court had established what he called the principle that, federal constitutional law constrains state courts or other state actors in the context of interpreting or implementing or applying state constitutions to state election statutes for federal elections. So we now have an endorsement of the weaker version of the doctrine. We had never had a majority of the court endorse any version of this doctrine. when Chief Justice Rehnquist wrote his concurrence in Bush v. Gore for 3 justices, which endorsed a different version of the doctrine, there was a lot of criticism, a lot of support, but that kind of lay dormant for all these years. Now, a majority of the court has not only endorsed the position of the Rehnquist concurrence in Bush v. Gore, but has actually extended it to the domain of state constitutional decision-making. And we just have no idea at this point what the boundaries of that principle or new doctrine, what they are or will be. And I think, just to close these comments off, there's no question that partisan actors are going to try to exploit this opening when it serves their partisan interests in the context of fights over 2024 election rules. And it doesn't take a lot of imagination for lawyers to turn these disputes over state election law into federal claims. So I think that is a shadow now hanging over the 2024 elections. It does introduce some uncertainty that we won't get worked out until we have a series of further decisions, probably mostly in the lower courts on this.
I want to delve deeper into this question. I've got a lot of subsidiary questions, how these cases get to federal court, et cetera. And I know Derek has written about that. But I want to, before doing that, turn to Bertrall and the bigger picture here. You know, what was hanging over this case was the 2020 election and Donald Trump's imploring of state legislatures to appoint their own slates of electors after voters had voted. You had some lawyers like John Eastman and Clayton Mitchell using ISLT as a basis for claiming that legislatures had this power. Bertrall, have we stepped away from the precipice with this ruling and with Congress passing electoral count act reform in December? Are we out of the woods?
I wish we were out of the woods, but unfortunately, I don't think we are. And I think a lot of this follows up on Rick Pildes' point earlier. I would say that there were 2 thumbs up for this decision in terms of protecting integrity and building trust over elections from this particular case. But there's one major thumb down from this particular case. So one thumb up was one that Caroline opined about or described, is rejecting the extreme version of ISLT. So it maintains a check in the system with respect to elections, and that state courts play an important checking function over state legislatures. Another thumbs up, so those are 2 kind of connected in terms of resolving an extreme version of ISLT and also maintaining state courts. But the thumbs down, and this is kind of really building on Rick's point, is that by making the point that state courts do not have free reign, but rather have there's some limitations on what they can do, that level of uncertainty can be manipulated and feed into the distrust about the elections to come. I think that Justice Thomas makes a very important point in his dissenting opinion that I think is worth reflecting on and thinking about. And his point was that, look, these disputes are going to arise in quickly evolving, politically charged controversies. And the winner of federal elections may be decided by a federal court's expedited judgments that a state court exceeded the bounds of ordinary judicial review. Now, when we think about 2020 and we think about the disputes that are arising right around the election that fed into the big lie, and we think about what's to come in 2024 with potentially the same contestants and the same issues arising, to throw this into the mix of the federal court potentially stepping in or not, or having to make decisions about whether to step in or not, with regards to these politically explosive disputes, raises that uncertainty and can feed into conspiracy theories that undermine the integrity of the election. So I think it's a step in the right direction, but I think there's concern with respect to the court leaving this matter undefined. If they go the route in terms of defining the federal court's role, in terms of reviewing what state courts do, in terms of interpreting their constitutions and statutes, and say that they're going to be very deferential towards the state courts, then I think that will be the ideal direction to go. But if there is some wiggle room in which they exercise discretion about when they're going to intervene and get themselves involved and enmesh in these political controversies, I think that that'll be a pretty important step backwards. But we do have the Electoral Count Reform Act that you mentioned as well, which is an important step forward I think that there have been efforts by Congress to move us closer to a point where we can have an election process that could proceed without the hiccups and the problems that are associated with 2020 elections, but we are certainly not out of the woods.
Let me just remind those who are watching this live that if you have questions for the panel, you can put them in the Q&A box at the bottom of your Zoom screen, and I'll try and get to some of those questions at the end. All right, so I want to delve into the court's holding and this vagueness that Rick Pildes was just talking about. Now, I want to ask it in the context of a dispute that was live back in 2020, which was we were in the middle of the pandemic. Voting was harder. The US mail system was not working as efficiently as it usually did. And some voters went to the Pennsylvania courts and they said, we think that the deadline for the extension of absentee ballots by election officials should be extended by 3 days in order to preserve the right to vote under the Pennsylvania state constitution. And the Pennsylvania Supreme Court agreed. They said, yeah, any ballots that come in within 3 days after the election, those will be counted. And Trump allies went to the US Supreme Court and said, this violates the independent state legislature. This violates the elections clause. Actually, it violates the electors clause to the extent we're talking about the presidential elections, the parallel provision in Article 2 that applies to presidential elections. And Justice Alito, who was the circuit justice at the time, he thought that was a plausible enough argument that he ordered the ballots segregated, the ones that came in those last 3 days. There were about 10,000 of those ballots. Biden won the state by about 80,000, so it didn't matter for the presidential election. But it could have, and it could have put the US Supreme Court in the position to decide who won Pennsylvania if those ballots were determinative. At the time it happened in 2020, we didn't know if ISLT was a thing or what it was. Now we sort of know. So what I want to ask each of you is, how is the Supreme Court going to resolve this question? And feel free to say need more information. But Derek, let me start with you. What do you think if this case comes up? What is the Supreme Court going to do with it?
Needs more information. I mean, you're looking at what facts you've got to get the 5 votes. I mean, frankly, that's what I'm looking. I mean, you have this standard that's fairly open-ended right now, and it's open-ended that can kind of go in almost any direction, right? It can be something that's extraordinarily narrow or something that's much broader, depending on where sort of the center of the court is. It's something, and I think Rick Pildes mentioned this, that Justice Kavanaugh sort of goes out of his way to think about whether the state courts are doing something new or different. Is there something else that doesn't logically follow from what the court has done in the past? I think the clarity with which the legislature has spoken matters. So when the legislature says Tuesday, that's a pretty firm deadline. And other standards, about, distinguishing may and musts or things like that in the statute might be subject to more review. So I think there are a whole bunch of caveats that show up for any point in time. And even though the court couldn't coalesce around a standard, I've been saying a lot this week to reporters that whatever standard it is, it's really about the court's mood and how they're applying that standard. Do they view this as a mood that's like really, really deferential, or is it deferential with sort of peeking through one eye and saying, we think you're doing something fishy here, or whatever it might be? So I think it's really open-ended about where the court might go and how egregious the facts are and how much the state court has been able to justify what it's done based upon the record in front of it.
So I take it that any deviation from what the legislature says in the statute, you've already now gotten Gorsuch's vote and Thomas's vote that's not allowed. And so then the question is, can you get to 3 more? So Carolyn, let me ask you how you think this might be resolved. And would it matter under Kavanaugh's kind of anti-novelty test? Would you have to go back and look at whether the state Supreme Court is usually using originalist methodology and then they deviate, or would you look at whether there were precedents that were close? Like, how are you going to operationalize this?
Well, that is the $1 million question. So I will say need more information. But I would say a couple of things. One is state courts have to be really meticulous about what they do. And I'm a bigger defender of what the Pennsylvania Supreme Court did in 2020 than some, because if you drill down into the opinion, all 7 justices agreed that the under the very particular circumstances involving COVID and the post office, the statutory scheme could not operate constitutionally. And the disagreement among the Pennsylvania justices was about remedy, not about whether or not the actual statutory scheme was constitutional. They said it wasn't. But they didn't do a great job of explaining all of that in ways that would speak to this particular type of review. And so I hope going forward that state courts will do that they will say, hey, we're doing something that might look different from, but if you take it in the context of our long history of how we've applied the right to vote under our Constitution, the type of equitable powers that state courts have, and that the legislatures have given us in the context of elections, et cetera, that is going to be, I think, very important to how the Supreme Court responds when somebody brings this type of ISLT claim, which of course they will. There's no question about that. The court will be asked to decide these questions. I'll just say one other thing, which is, the majority, Chief Justice Roberts it mentions Justice Souter and Justice Souter's opinion, as does Justice Kavanaugh. And Justice Souter's opinion really is quite explicit that this agreement over statutory interpretation is not a kind of going beyond the bounds of ordinary judicial review that he thinks might be reviewable by the Supreme Court. And so that's at least a clue that the majority thinks that there should be some meaningful deference here.
Rick, I want to get at this question for you by pointing to something in your op-ed in the New York Times today, where you talk about, you say I'm paraphrasing here, judicial minimalism is often a virtue, but not when it creates this kind of lack of clarity. And I was wondering if you could contrast this with what you've said about racial gerrymandering in Shaw versus Reno, where you've talked about how just putting a general rule out there is sometimes enough to create a kind of in terrorem effect in terms of what actors do. Could you defend what the Supreme Court did here as just telling state Supreme Courts, like, don't be extreme?
Yes. So a couple of things about that question and the general issue. You brought up the Pennsylvania Supreme Court extending the deadline for ballot receipt. I think we should also be asking, what about this North Carolina decision? Would the Supreme Court, under the standard laid out here, find the North Carolina court had actually violated the federal Constitution? I think we don't really have any idea about that. So we could talk about both of these cases. Now, to get to your question, Ned Foley had a very interesting post on the election law blog today, in which he basically said, this is part of what's going to happen. And he was celebrating it. He said, courts should understand that the Pennsylvania decision would not stand up after Moore versus Harper. This is his view. And he said state courts should get the message that they should stay much closer to, existing law and et cetera, et cetera. So Ned is envisioning what you're describing. He's envisioning the decision actually having significant effects, but not in a way we would see. Because if he's right about this, state courts are going to pull back from some of the things they might otherwise have been doing. Now, is that a good thing or a bad thing? Well, it depends a bit on what you think about decisions like the Pennsylvania Supreme Court decision. But if Ned is right about that, and if this is like Shaw versus Reno, when there's a certain internalization of a new boundary, and it leads legislatures to pull back, or state courts, I should say, or other state actors, that would mean that the proponents of the independent state legislature doctrine actually achieved a meaningful victory, even as they lost sort of on the major front that they were fighting. Because if we do notice, we may not even notice it, but if we do see a reining in of actions by state election administrators and state Supreme Courts, that would be a significant effect of the decision. Ned goes so far as to say that Pennsylvania decision would not hold up under this analysis. I'm not prepared to say that, because I don't think we have enough sense of what the content of the boundaries are and the standards. But that's pretty interesting in terms. So it's not just that the decision will cast uncertainty and shadows over 2024. It may have effects in 2024 that aren't quite as visible because it'll be this internal self-restraint that's emerging.
And I think, need more information. I'd want to read a whole lot of old Pennsylvania election cases before I would be able to say how much it's deviating. That's a very fact-specific kind of question, I think. But
I think Matt's position is like Derek's, which is if you have a date in a statute, changing the date, that goes beyond what Moore versus Harper would permit.
And you think that's true even if they ordinarily if they change dates all the time, and there's a history of them doing it for 50 years? I don't know. I mean,
what do you think?
Oh, so again, I think this gets to your point too earlier, Rick Pildes, on how you construe novelty, right? If the court has long said, well, in emergencies we change it, we've changed dates and blizzards going back to 1822, and we've changed, and they're able to sort of point to these things. Now it's harder. Again, I think the level of generality matters. The free and fair elections clause. What does that mean? What does that embody? What kind of judicial commitments are there to it? Does it? Even if they've never changed the date before, you're able to look back at these, pronouncements of James Wilson at the ratifying convention to say, like, this is how we conceive of the role of this free and fair elections clause. Again, I think it is so context specific and going to be heavily built on precedent, even with specific provisions.
Can I say something about that?
Yeah.
Oh, no,
I do want to get one more issue in here with Bertrall, which is the political valence, and then I'll come back to everyone. So, unsaid is that the Pennsylvania Supreme Court was dominated by Democrats and took a, expansive view of voting rights. It's easy to imagine running to a more conservative court. And so to give another example from 2020, during the pandemic, Harris County, Texas, decided to have drive-through voting to make it easier for people during the pandemic to be able to vote. They didn't have a lot of mail voting, was not allowed on an extensive basis in Texas. But so Harris County does this drive-through voting, and there's a state lawsuit that says you can't do it under state law. And eventually the state legislature changes the laws, makes it clear you can't have drive-through voting. But there's a federal lawsuit that's filed too, and it ends up being dismissed as moot. But Judge Oldham, who's a pretty conservative judge on the Fifth Circuit, says this violates the elections clause. So I'm wondering, are we going to see a lot of, cases involving Democratic state Supreme Courts or Democratic election administrators where they do something that Republicans or conservatives don't like, and they run to conservative judges in federal courts?
Yeah, I think you're going to see some of that. I think you're actually going to see it go both ways to a certain extent. But I think that with regards to the election disputes that arose in the 2020 election in particular, where there was efforts to provide greater access to voting at a time of a pandemic, there were opportunities to run to the conservative courthouses to try to get favorable opinions to overturn the decisions of state court judges or state executive officials. And so, but there could be a time in which that turns around, in which there are efforts perhaps to restrict the vote or make it a little bit more challenging that the court is willing to countenance, for which there's an opportunity to turn the other way and say that the court cannot do that given the provision of access that's been provided by the state legislature. So I don't know if it necessarily will have a partisan valence over the long term. I think in the short term, perhaps a partisan valence will be one in which there's a run to conservative courts for those favorable decisions. But I also say, in terms of thinking about this particular issue, is that when you think about sort of the state courts and their role in interpreting state constitutions, the state courts have a long history, but these clauses in state constitutions are very underdeveloped. There hasn't been interpretation and application of these clauses to controversies such as partisan gerrymandering. And returning to the question of whether the North Carolina partisan gerrymandering violates the free election clause, there wasn't a past of jurisprudence on this question to help guide the court. It was a novel issue. It was an issue that the court was trying to address for the first time. And so when you think about the anti-novelty argument or point that Justice Kavanaugh makes, well, a lot of these issues are going to be quite novel. And so is it every time the court is taking, state courts are taking on a matter of first impression or early impression and they resolve it in a particular way? Does that violate the anti-novelty doctrine to the extent that it is that? And if it does so, you're really depriving the courts of an important responsibility with respect to interpreting and applying their state constitutions. And then the final point that you raised earlier goes to methodology, right? And courts have different ways in which they interpret statutes in the Constitution. And so to the extent that the methodology deviates from how the federal courts ordinarily interpret and apply statutes in the Constitution, will that raise a question? I think that you're going to see state courts going to be feeling quite restrained and perhaps deterred from engaging in their constitutional responsibility under their state constitutions and interpreting state statutes. And going to your point that you made earlier, Rick, that if they are deterred, then those who advocated for the ISLT will have achieved a major victory here.
Carolyn, you wanted to say something a minute ago.
Yeah, it actually follows well on Bertrall's comments. I want to say something first about the novelty point. Justice Kavanaugh quotes from Chief Justice Rehnquist's concurring opinion in Bush versus Gore to make this point, that where there's some really dramatic change in what the state of the law is from before and after the whatever the state court does, that's at issue. But I think he's really pulling that language out of context, and I hope that this is an argument that will be pressed to the Supreme Court when, as I'm sure it will be asked to think about this. Chief Justice Rehnquist says that only after he's made it very clear that he's imputing a very specific intent to the Florida legislature that he thinks has to be honored above really everything else, which is the specific intent to take advantage of the safe harbor provision in the then existing Electoral Count Act. And that if there's going to be a change in the law, or even if Congress might think that there's a change in the law that would deprive Florida of access to that safe harbor provision, he thinks that would be inconsistent with what the legislature was doing. And that is just not going to be the particulars of many of these types of disputes. The Electoral Count Act has been amended. So there is something very specifically unique about that, the context in which Chief Justice Rehnquist talks about novelty, that I don't think Kavanaugh is acknowledging at all.
I'm going to get to the questions that are put in the Q&A in a minute. I just want to throw one more thing on the table and maybe start with Derek, because you posted on this, which is how do these issues end up in federal court besides the Supreme Court? We can see the path that goes to, state Supreme Court decides extend the deadline by 3 days, cert petition to the US Supreme Court. But election administrator does something like drive-through voting. Can you file an original action in a district court, federal district court? Like, how are these cases getting to the lower federal courts, if at all? I assume you can't take a state Supreme Court decision and appeal it to a federal district court.
No, right. So that is barred by Rooker-Feldman. So if we're getting deep in the federal courts world now, but yeah, I mean, in that posture where you're coming out of the state court system and the state court has this ruling, usually if we're dealing with the immediacy of an election, like you're petitioning for certiorari and that's it. You can try to run to a federal court if you weren't a party in that original litigation, so somebody else. But there's a lot of problems about who's as privity, who has a special relationship with those parties in the state court. I think we're going to see some interesting arguments in the near future. If a political party intervenes, will candidates or others who are represented by that political party, will they be deemed bound by that judgment? Other candidates who show up, but voters generally don't have standing to bring these challenges in federal court because they're generalized grievances. So I think when it's a state court decision, I think it's going to be much tougher. Now, the one thing, and Bertrall mentioned it, and Rick Pildes mentioned it earlier about the scope of this decision, I'm still on the fence about what this means for election administrators changing rules or what that looks like. you're right that if an election administrator says, "Oh, we're going to have drive-through voting," or as happened in Minnesota and North Carolina in 2020, we're entering into a consent decree with plaintiffs who have sued us as the executive official. If somebody runs to federal court and does that, what does that look like? This is a very state court-centric decision. Part 2 of the opinion is like Marbury versus Madison for state courts. It's just this sort of magnum opus about what judicial review looks like, right? And while there might be some analogies that carry over to the election official context, I'm still not sure what that's going to look like. That's probably where we're going to see more suits arising in the federal courts. But to me, that just raises more questions than answers about because election officials are not doing judicial review. They're executing statutes. So I am at a loss to think about what that's going to look like in 2024.
Jarek, I'm a little puzzled about that because, we know the Bush v. Gore concurrence is there and it's now been endorsed by a majority of the court. And that's in the context of interpreting statutes.
Yeah.
And I find it hard to imagine why it would be that state courts are barred from departing too far from the state statute, but state election administrators are free of this constitutional constraint. I feel pretty confident that this decision is going to impose the same constraints.
Yeah, it's not that I'm not confident that they're going to be constrained. It's that I just don't know what it looks like when you're not talking about the context of judicial review. There are discretionary actions expressly given in a lot of these statutes, or ambiguity left to be fleshed out in the administrative context to election officials that doesn't really play in the judicial context. I mean, maybe very rarely there's sort of judicial discretion, but I think I think it's going to look different in the application. So maybe it's the same thing that just looks different in application, but I just don't know how it as easily translates to a lot of election codes that often leave it to the discretion of election officials to figure out how to administer. That's all.
All right, let me turn to some of the questions that the audience has put in, and I'll answer the one that I can, which is, yes, this webinar will be recorded and you'll be able to watch it. It'll also be an episode of the ELB podcast, so you'll be able to treasure it and listen to it and watch as much as you like. All right, so the first question that someone asks is, if you don't like Robert's vague standard, for what I guess we're calling the weaker version of ISLT, what would you have put in place? Do you think there should be any kind of meaningful review of state court decisions in election cases? Open that up to any of you.
Oh, I think, yes, there should be. And I think the appropriate place to look is due process. I think that there should be federal court review if a state court really goes way off the rails. And it should be the same review with respect to federal elections that it is for state elections. I don't see that it should be meaningfully different. The big question mark that we've been sort of talking about is this: what does it mean to say beyond the ordinary bounds of judicial review? And I think that should be understood, and I hope it will be understood to be an extremely high bar that's akin to saying this state court has gone so far off the rails, it's not acting as a court, which is very different from saying, well, we don't like it, the state court used its equitable powers to change a deadline, or we don't like it because we disagree with this particular statutory interpretation. Those are very different types of analysis. And so I would say, yes, there is some limit, but it's a pretty broad one, pretty high.
So it's like an arbitrary and capricious standard, which would be
something like that.
Go ahead.
Sorry. No, I was just going to say that. If I just clear my throat, I agree with that point very much, and I think one thing that's important to recognize is that courts, as we all probably know, are not above politics, and especially when you are in a system with elected judges who may have their loyalty to party that may exceed their loyalty to their position, and may prevent them or act as an obstacle to exercising their role responsibly. So I do feel that it's important that there be some check on federal courts or state courts, in a sense, going well beyond what their role is. But I do think that the standard should be one ordinarily of deference, because I just don't want to I don't think federal courts should be involved in the business of how state courts are checking how state courts interpret their constitutions or even statutes that are ambiguous in particular.
I take it, and Carolyn or anyone can answer this, that the due process argument's not off the table. So imagine the deadline's extended by 3 days in Pennsylvania, and it affects the outcome of a governor's race. You obviously can't make an elections clause argument there, but you could make a due process argument and say that the state court decision was arbitrary and capricious, right? You still would have that option. It would just be harder to win. Is that right?
No, I don't know if I completely endorse arbitrary and capricious. I'd have to think about precisely what the language is. But yes, it should be hard to win. I mean, that's the point. It should be hard to win, whether it's for the presidency or for the governorship. I agree with Bertrall agrees with me. I agree with him. This should be something that is left for state courts to do. And I don't assume I am always going to agree with what state courts do, but at all. But they have an area in which they operate, and it may vary from state to state, right? Some state courts are going to have different types of powers than other state courts. Some state courts are going to be textualist, some of them aren't. And that's okay under our system. And to say, well, we, the federal courts, are going to step in and say, well, you didn't construe the statute closely enough to the text, or you didn't, you invoked these, you used your equitable powers in ways that we wouldn't have, I think is just inappropriate.
Go ahead, Derek.
Well, as a practical matter, I just wonder if any of you have thoughts on what would be the delta of difference between a due process arbitrary and capricious standard and the Roberts transgressing the ordinary bounds of judicial review or whatever. Like what difference is there in that form? I understand as law professors, we care about the clause and we care about the phrasing, but I wonder boots on the ground, what difference it might be.
Well, I mean, here's one difference. Carolyn actually or Rick identified another one, but it's related. As many of you know, one of the famous due process cases in the election context in state elections involved the Alabama Supreme Court. And the lower federal court just held, after extensive fact finding, that the Alabama Supreme Court had traditionally treated absentee ballots one way. Now it treated them differently. This was a state Supreme Court election, actually, as well. And they held that this violated due process. And you wouldn't be able to reach the actions of state courts or the actions of state election administrators that depart from past practices, but are not, those practices aren't codified in statute by the independent state legislature theory in its weaker version. So due process would be actually more expansive. Now I basically agree with Carolyn that that's a better basis for getting at the risk of various state actors manipulating state election law after the fact, after votes have been cast, or even maybe before votes have been cast. But I think, unlike Carolyn, I believe there is a distinct federal interest in the integrity of federal elections that the Constitution, properly kind of recognizes. I'm not sure that would change exactly the contours of this due process doctrine, but maybe you apply it with a little more teeth in the context of federal elections, because I do think there is a distinct federal interest the Constitution should be understood to recognize in the integrity of the federal election process.
Yeah, as Carolyn wrote in her article, I can't remember, was that in the Supreme Court Review? I can't remember where it was.
Chicago.
Right law school wrong journal. We could end up with, say, a situation where those 10,000 ballots at issue are counted in a state election, but not counted in a federal election. So they do raise all kinds of questions of election administration that are going to crop up if we have a separate rule in federal elections. I want to get to two more questions. They're both great questions. I think I'm going to throw them both on the table and give you each a chance to respond to either or both of them before we conclude. The first one is about strategy. And the question is, given Kavanaugh's concurrence in, say, Wisconsin, where the state Supreme Court has flipped to majority liberal, do you challenge a state legislative gerrymander first before you try and challenge to establish a principle that partisan gerrymandering violates the state constitution, and then challenge the congressional districts in order to show it's not novel? And then the other question is, Kavanaugh says in his concurrence, this is a rule that applies to state statutes and to state constitutions. What does it mean to respect the legislature when it comes to state constitutions? That's kind of a non sequitur. Two really great questions. So I'm going to just go around and ask each of you, since we're getting close to the end, to respond to either or both of these things. Let me start with Rick Pildes.
Well, on that first question, that's that's a very clever question. I enjoy that too. I don't know how to think about these tactical issues now. We just have the decision. I haven't begun to think in that way. It's very difficult because, of course, we don't know what kind of teeth this doctrine actually is going to have or not have. We don't know whether there's another justice in the majority of the court that's drawn to Justice Kavanaugh's approach, which does seem to be something about evulsive changes in state law or state interpretation. So I have to think about how I would think about this as a litigator or somebody advising litigation. That's a very, very interesting question. I should say this is easier in states that have express provisions on various issues, including state courts that expressly ban partisan gerrymandering, which a handful of state constitutions now do. I don't think there's any issue about those provisions and those provisions applying to federal elections and being enforced by state courts in federal elections. So that's a different situation in those states. What was the second question? Remind me.
About constitutional versus statutory interpretation and respect for the legislature. How do you know when there's too much deviation when it comes to state constitutions?
Well, I think this is a huge open question. I mean, I wrote about this a fair amount at the time of the argument. I saw the temptation within the court to extend the Bush v. Gore concurrence, to use that as a template for the constitutional domain. And I thought, as Justice Thomas said, actually, in picking up on a number of these issues in his dissent, state constitutional interpretation is very different than state statutory interpretation. With statutes, they're typically much more elaborate, much more detailed. You have a much firmer anchor in deciding what goes too far from the text. But many of these state constitutional provisions are drafted in as broad terms as the federal Constitution. We know that almost all of the major Supreme Court decisions under the federal Constitution in the law of democracy were these dramatic changes from past practice, whether it's the reapportionment revolution, one vote, one person, recognizing the right to vote as a fundamental right, et cetera, et cetera. We have all these puzzles that are raised about how you would apply this doctrine in the constitutional domain. Does there have to be state precedent that provides a toehold for the new decisions? Does it matter? Some states have these precedents, some states don't, but it's the same right to vote provision. It is a lot more difficult. I agree with Justice Thomas's dissent on this point. It is more difficult to anchor a judgment about how far is too far in the area of constitutional interpretation rather than statutory interpretation.
I jump in on the end of that point with Thomas's view, but specifically, it is analytically two different things we're dealing with: the statutes versus the Constitution. Right? When you're looking at the statute, you're trying to effectuate the will of the legislature, and then there's going to be fights about whether or not that's what the legislature really wanted, which in some ways is pretty messy. I mean, we saw that in Bush versus Gore play out about may and shall and trying to discern what the legislature wants. These constitutional cases, though, it really does pit the legislature against the court because the Constitution is being used to check a legislative enactment. And so it plays out a little bit differently as we're asking if the state court has strayed too much from the state constitution, but it pits the legislature's will very directly against what the court is doing, unlike the sort of ordinary statutory interpretation case.
Bertrall, you're muted.
Importantly, many of these state constitutional provisions are limitations on legislative power. And so to make the question about what the legislature wants with respect to the constitutional provision seems to be besides the point, because the focus of these provisions is to check legislative power. I guess I'll just kind of raise, in terms of the first question, with respect to how do you sort of, which way do you proceed? I also haven't thought that deeply about the strategy. It's a great question. It seems with the anti-novelty point, you would probably want to proceed with challenging the state partisan gerrymander before the federal partisan gerrymander, to eliminate the novelty point or at least reduce it. But there's still a question, and this is one of the things that I've been thinking about in terms of the phrase beyond the bounds of ordinary judicial review, is whether the court is getting at something, getting at the remedy question. And is there a concern about courts diving in, hiring special masters or whatnot to draw maps in the partisan gerrymandering or gerrymandering districting context? And one of the reasons why I think that the court decided this case, despite probably being moot, was that they didn't have to delve into the remedial question in this case, because that question was off the table. But that remedial question will likely come back on the table in future cases. And will the court be willing to countenance state courts being involved in the redrawing of district maps? Or will they consider that to be beyond the bounds of judicial review? And if it is beyond the bounds of judicial review, and the legislature says, we're not going to abide by we're not going to draw new maps, even though you've declared these old maps unconstitutional, we are in a pretty deep conundrum for which there's no clear resolution. So I think that that's an important point to also reflect on in terms of where this might all be heading, at least in the districting context.
All right, Carolyn, you get the last word. We've got 2 minutes left.
Well, I also don't really think I'm in a position at this moment to give anybody strategy advice, but I think the question points to the real muddle of mixing up federal court review of state courts and state courts' interpretation of their own constitutions. I mean, somebody earlier noted that most state Supreme Courts are elected. So presumably when the people of the state of North Carolina or the people of the state of Wisconsin, in a very hard fought election, choose justices who have indicated that they are going to interpret the state constitution a particular way, is that an evulsive change if then that justice then goes ahead and votes that way? Or is that the way the state is supposed to operate? And I think the Supreme Court, at least what we've been sort of alluding to, is the possibility that the US Supreme Court won't give state constitutional law that sort of allow for that kind of small d democratic input that is in fact inherent in what a lot of state courts do.
Well, I'm glad we answered all of the difficult questions related to Moore versus Harper. Sounds like there are a lot of law review articles to be written over the summer. Derek Muller, Carolyn Shapiro, Bertrall Ross, Rick Pildes, thanks for a great conversation, and I'm sure it won't be the last word on this case. And thank you all for listening. You can find out more about the events for the Safeguarding Democracy Project, including our soon-to-be-announced fall webinar series at safeguardingdemocracyproject.org. I'm Rick Hasson of UCLA Law. Thank you all so much for joining us. Bye-bye.